So is this to say that President Uhuru Kenyatta has a better working relationship with the new Chief Justice? And of course, there are those who will ask, is this actually how it's going to work? It should be about friendly ties between the head of the executive and the head of the judiciary. This is a night and the beginning of many weeks of very tough questions.
And interesting questions, Yvonne, including, I see Ahmed Nasir was saying a little earlier in one of his tweets that to his credit, CJ Maraga refused about 4 times a proposal to have 32 out of the 41 judges sworn to office by H.E. Uhuru. His retort, Maraga's, that is, all or none. That will be raising the question about whether the president has that option of, you know, saying this one yes, this one not. That is part of the raft of questions I would imagine that people will be asking, including what happens now.
I'm afraid what's happened is, while it might resolve the issue for the 34, but this opens up a whole other can of worms legally, you know, and with litigation. For me, it raises 2 questions, just to pick up from what Linus had said. So either it speaks to Chief Justice Martha Koome's diplomatic skills in terms of, you know, having a sit down with the president and saying, you know, let's get these judges on board. But then it does raise the question about the others who were not appointed, and whether this is something she was privy to, whether they sat down and had a discussion and, you know, did what is now being called the cherry picking, whether she agreed to this and said, okay, you know, so who shall it be? These 34, these 6, this one and this one, which then raises a whole other issue about the legality of the process. And remember, this is again in contravention of the court order that was given 1 year ago, where the courts ordered President Uhuru Kenyatta to appoint all the judges. Granted, there was no timeline. I think he was given 14 days, I think, yes, within which to do it, and they called his delay unconstitutional. And they also talked about, you know, the fact that this, for the presidency, according to our constitution now, is in essence a mechanical exercise for the president. He appoints. There is no legal provision, for instance, to cherry pick, nor is there a legal provision for him, because the law says he shall appoint upon recommendation by the JSC. Not will, not may, shall. And in legal terms, you know, there is no 2 ways about it. There will also be legal questions that will be asked about his decision to send the names back to the JSC. And again, it starts to raise further questions about, you know, if there's intelligence from the NIS or whatever. These are usually presented during the vetting process by the JSC, at which the president has no less than 3 representatives, 2 representing the public, I think, and then the Attorney General himself. Did these issues not come up? Also, the question is this: now we know, you know, who are the judges specifically that he has issue with. Is the president now telling us that he is comfortable to have these judges continue to sit at the judiciary, hear and determine cases if there are questions towards their integrity? So what does that mean? Should we now start to doubt all of that? And why not follow the legal procedure of forming a tribunal to, you know, look into their conduct or allegations of, you know, integrity on their part?
Jamila, you come in a minute, but Francis is smiling. Francis, I watched your story, which you turned around rather quickly, but I watched a story that, I watched a soundbite by the Attorney General, where he was basically saying that the president would not abdicate his responsibility when it comes to this matter. I mean, this, of course, was at the height of the standoff with the CJ Emeritus, now David Maraga, where he was basically explaining or perhaps justifying why the president had not appointed the 41, now 40 judges at that point in time. And I imagine that there will be arguments like that from the president's side, from the AG and other people who would be speaking for the president, that look, if, you know, there were questions around these things, the president cannot close his eyes.
Absolutely. For me, I look at it this way. It's not so much what has been said, but what has not been said. What are the reasons for not appointing these 41, now 40 judges? Because Harrison Okeche passed on before the appointments were made. And you asked Linus about the working relationship between the president and the new Chief Justice, Martha Koome. She's been in office barely 2 weeks.
2 weeks.
So I don't know whether we can talk about that working
relationship
relationship because it's been 2 weeks. But all the same, I wouldn't think she's a stranger to whatever happened today. I mean, this, I would believe firmly so, that she was kept in the loop about what happened. And it is also important to walk 1 or 2 steps back from the process of appointing her to be Chief Justice. Look at the composition of the Judicial Service Commission. That is where we ought to have seen this. 1, who are members of the Judicial Service Commission? How are they appointed? And what is the executive interest in the Judicial Service Commission? What is the amount of the executive representation in the Judicial Service Commission such that that representation can influence the choice of the Chief Justice, the Deputy Chief Justice, and other judges of various courts. That being the case, when the president decided to appoint 34 and not 40, 6 judges were declined. What were the reasons? Now that we are told that this was as a result of information delivered or brought or submitted by national security agencies, what is this information? Is it now an opportunity to make public that information? Bearing in mind
that some of those people are actually deciding cases.
Actually, four of the judges whose appointment the president declined to the Court of Appeal are serving in the High Court,
including Justice Joe Ngugi, who just today, sentenced the principal
of Kiru,
to 30 years in prison.
Yes. So, what is this information? Is it now possible to make it public? Because the information we have is that the president returned the 6 names back to the Judicial Service Commission and an addendum on reasons, specific reasons for each of the nominee, why their appointment has been declined. So 1, will the Judicial Service Commission return back the names to the president and tell him, no, those are the guys that we had settled on, deal with it? Or will the Judicial Service Commission say, okay, now that this has been raised, what do we do with it? I think the next most important question is, what next? Will we see tribunals established to investigate the conduct of these 4 judges and with a view to push for their removal? Because if they have integrity issues and they're currently in the High Court, then it means they ought not to be in that office if actually there are integrity questions about them. Another nominee whose appointment was rejected is the High Court Registrar, Judith Omange. High Court Registrar is a very powerful position. If you're saying she has integrity questions, then does she deserve to be in that office? So clear her or kick her out of office. The other rejected nominee is a chief magistrate who has been in the judiciary since the 90s. So if this person has integrity issues, then why would they continue to be in the judiciary if there are serious integrity issues? So is it the start of another bloodbath in the judiciary? Reminds you of the radical surgery back then by Justice Ringera. Is it an opportunity for that? You talked about a soundbite by Paul Kiara Kariuki, the Attorney General, and the soundbite is here, together with a rider from the then Chief Justice David Maraga.
Of particular concern is the fact that these emotive and highly charged public attacks by the Honourable Chief Justice have now taken a decisively personal slant.
Some of the individuals the executive claims to have adverse information against are serving judges. Some of the individuals the executive claims to have adverse information against are serving judges.
His Excellency the President will not abdicate his role as head of state and government to appoint persons with a questionable record to serve the nation in the solemn role of judge.
So, question then is, will the 34 judges proceed to accept the appointment and be sworn in? Or will they say, wait, let us first clear the issues about the other 6 judges so that we can be appointed together? Or will they take up the appointment and then the Judicial Service Commission is left to deal with the 6 nominees whose appointment was rejected? Lastly, in 2014, some 28 judges were nominated for or recommended for appointment by the then Judicial Service Commission. The president first appointed 10, then 18. Is that a precedent that the president has followed in this one? Only that time he rejected none. This time he has rejected 6. Some very interesting food for thought.
Jamila, it doesn't help that, I mean, in terms of the optics, that 2 of the rejected judges rejected BBI.
Yes, exactly. In fact, I was going to talk about timing, a question of timing. One, of course, you spoke about, it's just been 2 weeks since Lady Justice Kome was appointed as Chief Justice. And then now, these judges are among the 5 who rejected BBI. And now, the 7 who have been appointed, the ones who have been appointed to the Court of Appeal are being appointed at a time when we are waiting for the President of the Court of Appeal to name the 7 judges who will sit on the bench to hear the BBI cases. This is happening barely 2 days after the President censured the judiciary, especially the High Court, after that ruling that rejected BBI. And you look at it in terms of now those 2, among the ones who are rejected, the 2 who had been on that High Court bench that rejected BBI, it's Justice Ngugi and Justice Odunga. And Yvonne and Gashuri spoke about how there are reasons which were given for their rejection. But people will not see that, the optics again. They'll say, aha, these are the 2 who rejected BBI. So this could be a reason why they were rejected. Whatever reasons have been given that Gashuri mentioned and Yvonne, the NIS gave a report, there was an addendum and all that. When you look at someone like Justice Odunga, I was reading about it, he was once awarded Jurist of the Year because of the ruling of the case involving Miguna, where he said that some high-ranking government officials were in contempt of court when they refused to allow him to come back in the country. He was also involved in the case, in the award of the tender to the Al Ghurair company on the printing of presidential ballot papers. He was also involved, he declared unprocedural the appointment of returning officers for the 2017 general elections. It was just a day before the repeat poll. He was also honored for being the most efficient, for heading the most efficient court division. The Judiciary Performance Management and Measurement Evaluation Report showed that the Odunga-led Judicial Review Division at the Milimani Courts was the most efficient and faster in hearing and determining cases. These things are in the public domain.
I mean, even the National Security
Amendment Bill.
Yeah, he
exactly.
Yeah, the laws.
Sections of it unconstitutional.
And I remember when
that is the time actually members of Parliament wanted to censure him.
Yes.
I remember
Eden Duale, yes.
Other steps, yes.
Singling him out actually by name, that you, and in fact almost suggesting that tribal and playing politics and that sort of thing.
And when he was before the JSC in 2019 for this, when he was applying for this position, he was asked why all his rulings are against the government. And he said, for me, I look at the legality of it. If I think it's not legal, I'll look at the law, and that's how I make my ruling. So when people look at the caliber of such judges, because this is in the public domain, they ask themselves questions about why they were rejected. That's one. And two, you talked about how the Constitution, Article 166(1)(b) says that the President shall appoint all other judges in accordance with the recommendation of the Judicial Service Commission. When the names were forwarded in July 2019, then the 41 at the time expected it's just a formality that the names will be passed and they'll be made judges. But it didn't happen. That's until Adrian Kamotho moved to the High Court. And in February 2020, the court ruled that the President cannot consider afresh a list of nominees by JSC because as by law, he's supposed to just petition Majina because JSC is supposed to have done its job, done its due diligence, done its interviews by the time he's submitting the names. That same three-bench judge dismissed a petition that had been filed by David Kariuki Ngari, who had sought to defend the President's action on the basis that to hire 41 new judges would have been costly and not based on proper needs assessment by the JSC. So you look at it in terms of, Rais hajafata sheria because it is expected apitishe wote, but amepitisha kadha na amewacha kadha. So all these questions are in people's minds, those who understand the law and even those who don't, because people are speculating about the reasons why amekata hawa, including those two who are on the bench that rejected the BBI.
And I think that one of the things that the big burden, in my view, that at one level the President himself will have to deal with is that set of questions that people then have, because this is a matter that has been protracted for the last 2 years. It's been here in our faces. It keeps coming. It's a matter that brought the sort of bad blood that we saw between the last regime, as it were, in the judiciary and the president. And right now, barely 2 weeks, as we said, into the new administration of the judiciary, they are appointed. And then the judges that are left out, I mean, by all accounts, many people that talk about Justice Odunga, Professor Ngugi, all these people would say things like they are some of the most brilliant jurists that we have in the country. Some people would say that, you know, they are courageous judges who make decisions as long as the law is in their view on their side. They will make whatever decisions regardless of who it will run afoul of. So it seems to me that the questions that people are asking need to be answered, that people need to be satisfied that actually, one, that there are some grounds. But more fundamentally, I think, is the legal question that then will come. Obviously, it will be a big debate for lawyers and all of that, but it does appear that we are in uncharted territory here, where the JSC has finished its job, and the president is supposed to merely appoint the judges, because even when the names are taken back to the JSC, which process is that? Yeah. It's difficult to locate which process that is.
The law, yeah.
I mean, just think for a moment, if the other day after Parliament, JSC Parliament had approved the name of Martha Koome, then the president says, no, I have some questions about it.
And then sends it back to the JSC. What would they do?
Because there is no known sort of precedent on where to lay this, where the president says, I will not appoint them because they have, in fact, the list actually said that they did not meet the threshold, whatever that is. But that's really quite interesting.
Joe, I look at the original letter that was written by the Judicial Service Commission, then chaired by David Maraga, on the 13th of August 2019. Now, here are 6 judges, 6 nominees whose appointment has been rejected. The Judicial Service Commission, interestingly, is yet to say anything. Hours after the appointment, I would have probably expected even a brief statement telling us, we take notice of what the president has done, we agree or we don't agree with him, we'll give finer details later. Nothing yet. Still, no statement yet from the Judicial Service Commission after what we discussed here last week. No statement yet. So, does it say anything about the working relationship between the Judicial Service Commission and the executive? Random thoughts. Secondly,
Linus has been waiting.
Yeah, has been waiting for a while to look at it. Then lastly, as we let Linus in, is it also the curse of an insider in the judiciary, or the burden of choices? Because look, the 6 who have been rejected are insiders in the judiciary.
Burden of choices, that sounds familiar.
I was just looking at that.
Okay, Linus.
As we were told in Kisumu.
Yeah, burden of choices is in our next topic, I guess, which is coming in a short while. But
we'll choose to go there shortly.
Yes, but I wanted to say, other than the questions that people will be asking, we are also looking at the context, the totality of this context. This conversation would not have been possible just over 10 years ago. We are here because of the Constitution of Kenya 2010. And there is an admission that must now be made. One is the Constitution of Kenya 2010 is a nightmare for a president. Because President Uhuru Kenyatta occupies this unenviable position and finds himself in situations that the first 3 presidents of the country did not find themselves in. So there's a bit of a hangover of the old ways of doing things that is interfering a bit with the implementation of the Constitution. You see this clash going on, and this is the clash that we are witnessing. Because we've seen a president that has run into trouble with the law almost with the frequency of people that go home late during curfew. You know, there's been so many times. The chief administrative secretaries declared illegal the other day by the courts. Senior parastatal heads declared, the appointments declared illegal by the, because here is an exacting document. It's exacting in a way that departs from what we used to have in this country. The principles of the Constitution of Kenya 2010, the silent one, is redistribution of power and making power accountable. If he were President Jomo Kenyatta, Daniel Arap Moi, or Mwai Kibaki, all these questions will not really arise. He'll appoint the judges he wants. It's within his power. But came the Constitution of Kenya 2010 and tells him in 166(1) that you shall appoint. You're a conveyor belt. It's a very polite way of telling you, no, you're not going to do much. Just get the names from JSC and transmit them onwards. Here is a second thing that I think must be found unfortunate about the situation President Uhuru Kenyatta finds himself in. The interventions, and in political power you can intervene. You know, you should be interested in who becomes the Chief Justice. You should be interested in who becomes Court of Appeal judge. That is part of your, it's your right, really. You are in power, and you serve for a particular term. You would want decisions to go a certain way. So it's a legitimate right, in my view, of a political player to have an interest in who occupies those offices. But here is one thing that must be found faulty of the President Kenyatta administration. Every intervention has come too late in the day. Whether you are even talking about the BBI decision the other day, there are so many checkpoints that were missed, legally speaking. And when it comes to this issue of appointment of judges, it has taken 2 years. Why should it take 2 years? Because you are legally in a quagmire. There is something that the state law office that is supposed to advise you may not be doing right. We have presidents who have done things and they have the means to do these things. Let's talk about the 6, Francis, that we now say have issues. Now, intelligence services would know those issues before even the JSC sits.
Yes.
Why didn't they do it back room? The way governments work. You are given those instruments and they work in the back end so that you tidy things up. You will actually tell JSC, you know, Justice so-and-so is a crook. Justice so-and-so is dealing in drugs. Justice so-and-so is...
we don't even need to know it came from NIS.
Yes.
I mean, that's none of our business.
So why wait till this end and come enter into an argument with the likes of Ahmed Nasir, Utai Ngugi? You know, it becomes a public sort of spat. And this is the unfortunate situation where the president has found himself in. He has been, and I want to compare him, and he did compare himself with the first 3. I want to compare him in terms of the state law office and the previous administrators, the previous presidents rather. You would find that under Jomo Kenyatta, with Charles Njonjo in the office of the Attorney General, it was a tidy affair. There was a time they needed the Chief Justice to serve longer than the law allows. What did they do? Chief Justice James Weeks, I think. They had to amend the law twice. Every time the gentleman acquired the retirement age, the law was changed to increase the retirement age so that it stays on. The thing is, act legally. Change the law if you want to act in a certain way. Because the problem President Uhuru Kenyatta finds himself in is in a shouting match with the Constitution. And so far, it's suffered a lot of losses because of that.
And it would have been great if, for example, I mean, the BBI thing that they've been pushing. There are a lot of these things that, I mean, if, for example, we had seen in that BBI proposal that says, you know, if the president has a problem with any, then he can return it to the JSC, you know, in a way trying to deal with preemptive with this kind of thing. But we haven't seen that. And what you are saying, Lina, I think is quite interesting. The whole idea that this constitution was in many respects, a direct response to what was seen as executive overreach, the overbearing nature of the president's office in those days, where the presidency was basically able to decide, almost decide whether you will have oxygen to breathe or not. And I think that is why our constitution put in place so many constraints on that office, because there was experience in this country all across the 3 previous administrations, mainly the first 2. I mean, there was a little bit of that also in the 3rd one, but I think we had already started getting into that mood of changing things a little bit. I remember President Kibaki attempting to appoint a Chief Justice and Attorney General, and I think DPP or something, and actually the court ruled him out of order, and it stood. But it seems that that has not really registered, that, you know, in the way that the late Okoth Ogendo would talk about constitutions without constitutionalism, that we have constitutions, but the hardware is there, but the software like virtually different when it comes to the software, and we need to take a break.
Yes, as we take it, V2 core ground and the difference. I've had an argument that what would have been the need for the president to appoint the 6 recommended judges to the respective offices, 4 in the Court of Appeal and 2 to the High Court, and then immediately a process of their removal is instituted. Why not appoint some who have no problem while, you know, shelving the rest? The question of whether these appointments are collective or each judge is appointed individually. I've heard that argument from those who support what the president has done today. But what I find more fundamental is that those 6 nominees immediately were handed, you see that thing that DCI guys give you of a suspect? They have been handed that. So everybody they meet will be looking at them as suspects. What could you have done?
What have you done?
What have you done? Why has your nomination been rejected?
And litigants who go before them.
Which is why, Francis, I speak of the back end.
Yeah,
government ought to have a back end, and it does have a back end.
Precisely, and that's why I was saying. That's what I was saying. Imagine somebody who has a matter before Justice Odunga, Justice Joel Ngugi, Justice Muchelule, and Justice Weldon Korir tomorrow. What about somebody who has a matter before Chief Magistrate Evans Makori tomorrow? What about somebody who will get a direction from Judith Omange, the High Court Registrar? How do you look at them? If it is against you, if that decision is made against you, do you look at them as, no wonder their appointment was rejected? So it is in the interest of these 6 judges, the Judicial Service Commission, and the country at large to know what exactly is the problem with these 6, so that people can make a decision, that's not worth it, or they can say, hey, okay, this is a serious matter.
I just wanted to add on the issue of the back end. That back end does exist, and that is the JSC vetting process, at which, by the way, all of those things are presented before the JSC. All of those issues from the EACC, the DCI, the NIS, all of those reports, including remember, members of the public can present, you know, their concerns or their issues as to why Justice so-and-so or candidate XYZ is not fit for that office. And again, to reiterate that the president, in some way, the Constitution has allowed him in some way a say in the process. That is why he's got 3 representatives. In fact, I think probably more than any other, the president is highly represented at the JSC. So the question is, did the NIS then, now we start to ask the questions, did the NIS, the ACC, or whoever has all of these issues against these said persons not issue, you know, the reports that they had on these individuals during the JSC?
Or were those reports ignored during the vetting process?
In which case we would fault all of these investigative and intelligence agencies. Or were they ignored and then brought afterwards? Those are some of the questions we should ask. But that the president does have a moment in which he can exert influence over the process, and that is through his 3 representatives there, including no less than the Attorney General, who is the chief legal advisor to the executive. And so that is the moment right there to keep it tidy, finish it, and sort out the matter there, such that those names would never have been forwarded to the president to begin with if they had issues.
Of quick note.
So Linda's finish, then you take us to the break.
Of quick note, that's a checkpoint that has already been passed. If you look at 166, it doesn't allow a reverse, you know, where you can go back and tell the JSC, by the way, relook into this. A 166.1 states that the president shall appoint all other judges, that's 1B, all other judges in accordance with the recommendation of the Judicial Service Commission. The option of returning the names to JSC is not available.
As I take the break, those 41 were not the only ones who applied for that position. There were many who applied. Wakachujwa the way you normally chuja, kukakuwa na short list. So that vetting process started way back kwanzia wakati watu waki-apply. And that raises all those questions you're bringing up, Yvonne. That were the reports ignored? They were not well done? Or if this 41 who are recommended by JSC was enough due diligence not done back then, that's why at this point at the end maswali yanaibuka kuhusu the ones who are rejected. So people are going to ask questions even going forward in future about whether the JSC is doing its job as it's supposed to, because if it had, maybe we would not be seeing this. But that being said and done, we talked about what people are saying, and I was looking through the social media. All those other issues around integrity, NIS, or the reports about who these guys are not mattering at all. People are looking at what they see, which is some of these judges, the perception, ile kitu tunaona, inaonyesha kwamba 2 of them were rejected because of the ruling that they gave against the BBI. All those other things actually at this point in time don't matter.
You will deal with that perception when the reports that were sent to the Judicial Service Commission will be made public. I hope that happens.
And you'll deal
soon.
with it after the break.
Two perfect strangers.
You look beautiful.
Let me remember this moment.
A fictitious love affair.